As I said, this will be recorded, and I'm going to turn it on now. So thank you everyone for coming to the Branford Forum today. It's a pleasure to host Professor Christina Rodriguez, who will be speaking on the President and immigration law. Thank you very much, Professor Rodriguez. It's all yours.
Thank you so much, Dan. I'm really happy to be here this afternoon. Thank you for inviting me to speak to this group. I'm excited to talk about this book called The President and Immigration Law that my co-author Adam Cox and I published in September of 2020. And it's actually the product of a 12-year collaboration between the two of us. The book itself has been in progress for about 5 to 6 years. And it's about what we call presidential immigration law. And that's a phenomenon that is everywhere in our contemporary politics. Perhaps the foremost example of that has become more or less a household term is President Obama's DACA policy of 2012, which was the effort to extend relief to immigrants without status who were brought to the United States as children and allow them to work in the United States. And this was itself the largest change in immigration law in a generation. President Trump's early actions also are reflective of this phenomenon. His so-called travel ban or entry ban of nationals from majority Muslim countries around the world were the product of a sweeping power that Congress delegated to the president in the wake of the Cold War. And this policy devolved into family separation and the virtual shutdown of refugee resettlement and a full-on effort to dismantle the asylum system in the name of border protection and public health. And one of the first things President Biden did when he was inaugurated was to issue, well, a number of executive orders across the regulatory world, but several of them focused on immigration law. President Biden was on track to equal FDR in the number of executive orders he issued in the first 3 months in office. And he immediately reversed some of President Trump's actions and initiated a variety of policy processes that are playing themselves out in the Departments of Homeland Security and the Department of Justice. And through these orders, he offers us a completely distinct vision of immigration law and policy to the one that was advanced by the Trump administration. So how is it that our system can go from one extreme to the next, not just in the rhetoric that comes out of the office of the president, but also in the policy that shapes the scope and reach of immigration law? How that is the story that we seek to tell in this book. And we argue that the roots of the president's power are not what people commonly think today. It's not that we're a highly polarized country and immigration is a wedge issue, and that because Congress can't act, the president asserts his authority and is increasingly becoming unilateral in all of his actions because of this polarization. At least with respect to immigration law, the story actually has its roots 100 years ago. And the president today has the power that he does over the system because of the product of a centuries-long transformation in the way our immigration law and policy are structured. And that power arises primarily from his most basic constitutional duty, which is to take care that the laws are faithfully executed. So I'll start by explaining how the fact that the president has the power to take care that the laws are faithfully executed means that he's in a position to exert lots of control over immigration policy, and then say a few words about how we should think about that, what that says about the future of immigration policy, what it says about our constitutional system and the separation of powers. And then I'm happy to talk about immigration law and policy and the president's role in it in any of its manifestations that are of interest to this group. So one of the very earliest constitutional controversies in American history was over the Alien and Sedition Acts, which most people think of in terms of the Sedition Act, which punished people critical of high-level government officials. But the Alien Acts were important and aggressive assertions of both congressional and presidential authority very early in the life of the Republic. And the so-called Alien Friends Act gave the president power to deport all aliens, non-citizens, that he deemed dangerous to the peace and safety of the United States. This was an enormously significant power, and it generated immediate constitutional controversy for two reasons. One is that people like James Madison and Thomas Jefferson didn't actually think the Constitution allowed Congress to give this kind of power to the president. And the other reason was because the statute was clearly, like the Sedition Acts, targeted at the critics of the Jefferson administration. And in this case, with the Alien Act, targeted at French immigrants in particular, who were thought to be sympathizers with Jefferson. So it was part of this very pitched political battle of this period. And in fact, several states enacted interposition resolutions, they were called, arguing that they would refuse to allow these laws to be enforced, and almost precipitated a constitutional controversy, probably because it was unclear that Congress actually had this power. John Adams never actually used the law, either to deport someone who was actually dangerous or to advance his own political prerogatives, and the Alien Friends Act was allowed to expire. But after that, Congress was essentially quiet on the subject of immigration policy. It wasn't until the late 19th century that Congress enacted or began enacting immigration laws that resemble the ones that we have today. It was, in fact, the states who regulated the movement of people through regulating whether paupers could come into their jurisdiction, and by imposing head taxes and landing taxes on people arriving on ships from abroad. And there were some states, Massachusetts being the best example, that attempted to create their own deportation systems. Massachusetts in the 1830s actually had a deportation law, and the eastern seaboard states in particular were resistant to allowing new immigrants, especially at this time Irish immigrants, to land, and looked for ways to repel them or prevent them from coming. There were other states in what was then the West, Ohio, Illinois, places in that part of the country, who actually sought to attract immigrants. And it was through incentives to own land and things of that sort that they sought to draw immigrants to the United States. But this was all happening essentially in the absence of congressional regulation. And there were a number of reasons why Congress was quiet. One was because of the unresolved scope of their power from the early republic, but Congress was also concerned at the time, before the Civil War, about regulating the movement of people, because that would potentially have been seen as weighing in on the subject of whether Congress could regulate the expansion of slavery as an institution. So the debates over that in part kept Congress out of immigration regulation. But fast forward through the Civil War in a number of decades, Congress comes under pressure in the late 19th century to start exerting authority to regulate who's coming into the country and who's not. And this pressure came primarily from the congressional delegation from California and other Pacific Northwest states who had grown tired of the Chinese immigrants who had come to the United States. They'd come in the mid-19th century to first in response to the gold rush, but then to help build the transcontinental railroad. And of course, many people ended up settling. But once the railroad was constructed and people began moving into the cities and setting up businesses in places like San Francisco, the population in California grew restive and started looking for ways to expel Chinese immigrants. And this eventually became the Chinese Exclusion Acts of the late 19th century, one of which asserted the authority to exclude immigrants, primarily Chinese immigrants from the United States, and the other, which asserted the authority to deport non-citizens. In the case of the statute that was enacted at the time, Chinese who could not prove that they had a right to be inside the United States. So it was in the late 19th century that Congress asserts its authority and begins to create the kind of immigration system we have today, where there are criteria for entering that are grounded both in family ties and whether someone is going to take up a job or perform some labor function, or and laws that also authorized the deportation of non-citizens who failed to meet certain conditions or committed crimes or things of that sort once they were present in the United States. So by this point, it might have seemed, given that Congress was beginning to assert its power, that any authority the president might have to control immigration law would diminish. The code over the course of the late 19th, early 20th century becomes more and more elaborate. It eventually matures in the 1920s into the national origins quotas, which kept very low the number of immigrants who could come from Southern and Eastern Europe in order to prioritize immigrants who came from Northern and Western Europe, and it excluded Asian immigrants almost entirely. And yet, it was this very elaboration of a code that begins to empower the president. And this is where our story begins. And we show how there were three developments that happened between the late 19th century and our present day that ensured that it would be the president who would shape both immigration policy and also immigration politics, and would put the president and the presidency in the center of the debates that the country has over immigration. So the first of these developments is the rise of this deportation system that I mentioned. Deportation, as I said, was not something that was available as a government power before the late 19th century. And even when it was first enacted, it was limited in scope. It was either targeted at the Chinese population with the Chinese Exclusion Acts, or the deportation laws that Congress adopted came with statutes of limitations. So if you came in and committed an offense that was deportable within the first 5 years, then you might be removed. But there were statutes of limitations that prevented deportation from extending as a power over the non-citizen for too long. Those quickly fall by the wayside. And over the course of the 20th century, Congress adds more and more grounds that make people deportable. Particularly drug offenses and other kinds of criminal offenses. And this as a whole makes immigration status contingent. It makes the immigration system probationary and gives the executive the power to determine, depending on whether someone has violated one of the many provisions of the law, whether someone can remain or is going to be removed through the initiation of deportation. The second really important development, and this is one that has lots of consequences for our present moment and has kind of been accelerated over the last 20 years, was the creation of a massive deportation state. So we could have laws that make people deportable, but if you don't have a bureaucracy or a police that facilitates deportation, then those laws are not effectual. Before the 1920s, there was very limited enforcement at the border. Even though there were restrictions on who could enter, there was very limited federal enforcement at the border, and there was almost no enforcement in the interior. Congress creates the Border Patrol in 1924 and starts on the southern border to begin to build up the capacity to prevent people from entering. And over the course of the 20th century, engages in a kind of secular increase in the amount of personnel and resources that are given to the immigration enforcement bureaucracy. Their powers expand and their size expand, so that today, the immigration enforcement arms of the government, which are Immigration and Customs Enforcement, Customs and Border Patrol, have a larger budget than all other federal law enforcement combined. And there are more people incarcerated in federal immigration detention than in the rest of the federal criminal justice system. And the size of the deportation state enables the government to remove upwards of 400,000 people a year, which is a target that the Obama administration hit on a number of occasions. So both the last administration and this one are well below that 400,000 number. And then the third development that coincides with this creation of a probationary system and a massive state to enable deportation is a dramatic acceleration of illegal immigration in the late 20th century. The phenomenon begins around the early 1970s, and it reaches its peak somewhere around 2007, but is really a significant force in the 1990s. And there are lots of competing explanations for why this happened over the course of a 30 to 40 year period, and why it now essentially is at a net zero. And I'm very happy to talk about those those competing explanations. Some of them are complementary, but there are explanations from historians and sociologists and economists, but they revolve a lot around the boom in housing construction, the differential wages between the United States and Mexico, the young population, the youth of the population in Mexico during this period, and the economic development of Mexico, which prompted out migration. But the significance of this dramatic expansion in illegal immigration is that the United States ends up with a population of, at its peak, 12 million people. Today it's closer to about 10.5 million people who are here without authorization. And the immigration code makes them removable by virtue of not having legal authorization. But that turns out to be many millions more people that can actually be removed from the United States. And here's where all of the pieces of the system come together to empower the president. Because it's not possible, even though we have a massive deportation system, to remove these many millions of people, choices have to be made, and those choices fall under the constitutional authority of the executive branch. And so the president, both rhetorically and as a matter of policy, has the power to shape who stays and who remains. And one of the stories we tell in the book is about how President Obama's DACA policy is the culmination of these dynamics. It was a bold assertion of authority, the constitutionality of which is debated, that conveyed the decision that people who were brought to the United States as youth did not deserve to be removed, and that enforcement resources would not be used to remove that population. So this authority that the structure of the law effectively gives the president is an authority that we refer to as de facto delegation. Even though Congress did not expressly authorize policies like DACA, we say that the structure of the law means that this sort of authority is effectively in the president's hands. So of course, the question is what to do about that, whether we should think about that significant power as being anti-constitutional. Does it raise concerns about the rule of law because the power is exercised through mechanisms like arrest, detention, and removal, which has highly destabilizing consequences for the families and communities that are connected to those who are removed? And how should we reform the system to address any of the problems that arise as a result of this incredible power that the administration has? So when we tackle the reform question, or sort of the analysis and then reform question, we take two approaches. The first is to say, well, this is the system that we have. Congress has not shown the ability to enact comprehensive reform that would fundamentally change this system. And so instead of resisting presidential control over the system and arguing that presidential unilateralism is dangerous, how should we conceptualize presidential control so that it manages this system effectively? And so a lot of the book is focused on what role the president can play in controlling law enforcement bureaucracies and shaping the way that they interact with the public and use their power in order to regulate the non-citizen population. And in the case of the Obama administration, his signature initiatives were primarily focused on controlling the line agents, the agents in the field who resisted prioritizing enforcement, in the sense that they weren't interested in determining whether someone was an enforcement priority or not. They just sought to enforce the law with whoever came into contact with the system. Resistance by the line level officials led to a lot of conflicts during the Obama years, not only with the White House, but primarily with the Secretary of Homeland Security. It was a constant tension between high-level officials and people in the field, in part because the Department of Homeland Security is made up of a law enforcement bureaucracy whose primary interest and professional identity revolves around enforcing the law. But we argue that efforts by an administration to try to control line agents are perfectly consistent with the president's authority to supervise the executive branch, and in fact, turn out to be, that this assertion of control turns out to be a way of injecting some humanity into a massive deportation regime that has all kinds of negative consequences for the communities under threat from that regime. The Trump administration used its authority over the executive branch in a different way. It's important to understand that under his presidency, the administration was also engaged in a lot of top-down management of the immigration system, but Trump and his Attorney General, Jeff Sessions, sought to control a different aspect of the system. They wanted to control the immigration judges, who they perceived to be standing in the way of a rapid deportation regime. So the control that they asserted was to speed up the deportation regime and find the places in the system that were slowing deportation down. And that included the immigration judges and those who were seeking to expand the concept of asylum in order to enable more claims to be recognized during these years. So if we leave the story where it is, which is without Congress acting, then I think what we end up with is administrations changing hands and the shape of immigration policy changing as a result of new people in authority with different visions for the system. And yet, even when you have someone like a President Biden, who, unlike any predecessor, including President Obama, comes into office articulating a comprehensive vision for immigration law and policy that explicitly repudiates the vision of his predecessor, it still remains difficult to move the system on a dime, in part because of the size of the enforcement bureaucracy, but also because of the intractability of the problem that there remain many millions of people who are in the United States without legal authorization and subject to deportation. And so this is where, in the book, we transition to offering a different vision, both for immigration policy and for the president's role in it. And so I'll say a little bit about what that vision entails. And it's the least legal dimension of the book, because it's not an analysis of the legal structure of the law, but rather a conceptualization of an alternative to the kind of system that we have today. And it's an alternative that can only be realized through action by Congress. And as we, I'm sure, all appreciate, getting Congress to act in a way that is radical is difficult to accomplish for many reasons, but not least of which is the division that exists in the country on lots of issues, including what to do about immigration law. But the vision that we offer starts from the premise that this system, this deportation system, and the shadow system of immigration law, where you have many millions of people present without authorization, is untenable, that it presents a number of rule of law and human rights concerns because it empowers an enforcement bureaucracy to control the lives of the people subject to it, and that regardless of the reasons for someone's presence without authorization, that the vast majority of the people who fit into this population have been in the United States for more than 10 years, and in many cases for decades, and that it's long past time to recognize that they've become integrated, that they're connected through family ties to US citizens, and they are in fact the essential workers, many of the essential workers and frontline workers of the COVID-19 pandemic. And so the first step in changing the very nature of the system to remove the enforcement logic at its heart is a legalization program. Even something like DACA, which President Biden has promised to fortify and will continue to defend in court, remains subject to litigation, is a contingent status. And it's only Congress that can extend the ultimate security, which is recognized legal status and an ultimate pathway to naturalization, which Congress has the authority to regulate under the Constitution. And so the argument is in part from both a rule of law and from a humanitarian perspective that legalization is vital. But that doesn't mean that the executive then would be out of the picture, that the president would no longer have a role to play in managing the system. Instead, we would reconceptualize his role. And one of the goals we have with the book is to talk about presidential power in a more nuanced way than is often done in conversation, where you either think that presidential power is a threat to our system of separation of powers, or you think that Congress should not have the authority to trim the president's sails. It's instead to say that there are some forms of presidential power that are constructive and ought to be harnessed and enable us as a country to solve problems that need resolution. And there are other forms of executive and presidential power that do require more control. And so we should shift the president's role in the system to those kinds of power that are more transparent and that are focused on the unique capacities an executive has to problem solve in relation to a Congress that is much slower to act than an executive branch. And that would entail a number of different things. That could entail giving the president the power to admit non-citizens to the country on his or her own initiative, which is to say, if the country is facing a crisis, like some say we're facing right now at the southern border, with hundreds of thousands of people, tens of thousands of people seeking entry because they're fleeing violence in Central America, the only tools that the president has to deal with that are ones that involve exclusion, and the ability to admit people, even for a temporary period, is limited. But we think those kinds of tools would actually be quite useful in addressing a crisis, and enabling the methods by which the government goes about addressing them to not just involve detention and coercion and removal, but also resettlement and the like. And so that's the way in which we would begin to reimagine the president's role and bring the problem solving and quick action features of executive decision making to bear on immigration policy. All of that, of course, presumes that people share both the vision that we offer for immigration law and policy towards one that is more inclusive, that is readier on an ongoing and consistent basis to recognize that people who initially don't have status ought to be quickly incorporated, and that people also share our view that presidential power, even if it's strong and robust, can be constructive and doesn't threaten Congress's role as the legislative body or threaten individual rights or the rule of law, that in fact, robust forms of presidential power can be made consistent with those values. But we do think that in the end, the way that presidents have exerted their power over immigration law has actually moved us closer to this moment of reform, that the political back and forth that we've seen now over the last 3, arguably even 4 administrations has made salient for a wider swath of the public what's actually at stake in our immigration system, and a greater number of officials and lawmakers have become invested in the way the system operates and the way that Biden announced his administration with a number of executive orders directed precisely at this issue, I think exemplifies that change in the political dimensions of the issue. And I hope that the political will reflected in that can be sustained in a way that leads us down to a more constructive system than the one that we've labored under for the last 40 years. And so I'll leave the opening comments at that, and I'm really happy to talk about what is of interest to everyone here.
Well, thank you so much. That was fascinating. And if anybody has questions, you can either raise your hand or enter it into the chat. So just to start it off, to what extent does the Congress and the president sort of grab at power or want the power, and to what extent is it a hot potato issue where the Congress says, hey, we don't know how to do this, you deal with it?
Yeah, that's a great question. And there's, in one part of the book, we offer our account of what we think is really going on or has been going on over the last 40 years, which is to say that Congress actually wants the executive to be making these tough decisions and has essentially evaded responsibility to address, in our case, the problem that we identify as the large unauthorized population in any coherent way other than leaving it to the executive branch to manage. There's both a kind of positive and slightly more sinister version of that story. The positive version is that these are issues over which it's very hard to find consensus, and there might be some members of Congress who would have, 10, 15, 20 years ago preferred a legalization program or wanted to create more visas that would allow more laborers to come in a lawful fashion, but that there just wasn't enough political will to do that. And so having overly broad deportation laws from their point of view, but then relying on the executive to forbear from removing is a second best kind of option. The more sinister version of that is that there are lots of interests that benefit from having an unauthorized population in the United States, because these are people who don't have lots of legal rights. It's not that they don't have any protections. There are a lot of employment laws and labor laws that do extend to people without status, and there are certain constitutional protections that would extend to them. But employers have an enormous amount of power over people without status, and study after study will show that where you have a sector that is dominated by people who are not authorized to work, that labor conditions are less good, and that is in the interest of certain kinds of employers. And there are lots of episodes throughout US history where the agricultural sector, for example, has shown its preference for malleable labor, and that is often labor that doesn't have immigration status. And so that version of the story is one about our reliance on low wage labor and the lack of willingness to enforce the labor laws and make the jobs that unauthorized immigrants are doing sufficiently attractive to citizens. And that maintaining that is a reason why Congress has not enacted legalization or taken really truly seriously that the existence of an unauthorized population presents a problem that needs to be addressed. And so we offer both of those as plausible ways of understanding where we are. And that's one of the reasons to be pessimistic about long-term reform.
So in your more humanitarian policy, where would the potential immigrants be applying? Because it seems as if sort of an open border policy at the border creates all kinds of serious humanitarian issues, whereas if it were handled, say, in the consulate system, where the consulates were more generous and the border was less generous, I kind of stem the caravans and all this kind of nonsense.
Yeah, so there are a lot of different ways to think about it. What you just hit on is a strategy that the current administration is pursuing, which is to create infrastructure in the countries of Central America for people to apply for various forms of humanitarian visas. They would have to, under existing law, demonstrate that they fit within the definition of a refugee, which requires showing that they fear persecution on account of certain grounds that the law recognizes as ones that people should not be targeted for having. But you could also imagine a system that expands the categories of protection and focuses not just on who counts as a refugee, but to have a ground of protection be fleeing widespread violence, which is what many people in Central America are fleeing, gang violence, and there are a lot of women fleeing domestic violence in the home. And there's governments unable or unwilling to protect them from those kinds of violence. And so you could within existing law do handle things that way, but we also think that there's room to give the president authority to expand the categories that might be recognized. Now, there are all kinds of design questions that arise from that. Are people admitted on a temporary basis? Are they given a status that will eventually allow them to become permanent residents and then citizens? Those are all the kinds of details that would be worked out. But creating mechanisms by which people can be admitted and expanding the concept of protection at a high level, we think is the right combination. The other kind of approach that is perfectly consistent with this, but addresses a different kind of issue, is to give an executive official, it doesn't have to be Secretary of Homeland Security, you could create a different agency that does this, the ability to expand the number of visas for labor depending on the demand. So one of the reasons why you saw a lot of the migration that happened in the late 20th century happening illegally was because there weren't actually legal channels for workers to enter the United States. And yet there was significant demand for those workers in, especially in the construction industry, in meat packing, in domestic service, in hotels and places like that, and sectors like that. And so when people say that those who came to fill these jobs ought to have stood in line, there was no line for many of them to stand in, either because they didn't have the requisite family connection or because there's only a tiny number of visas available for laborers, people who don't have professional or advanced degrees. And so there have been proposals to give an executive branch agency or official the ability to adjust the number of visas of this sort that are available depending on labor market conditions. So to be more responsive to the world around us and not assume that a fixed number of visas are required in any given year, when of course the labor market can be volatile, and over the course of a 50-year period, its needs change dramatically. And so you want a system that's better able to adapt to that. And we also advocate that kind of approach that is a classic, this is how the executive has an advantage over Congress kind of approach. Congress cannot constantly change the visa numbers in the law. It just doesn't have the alacrity, even in good times, to be responding in that fashion to facts on the ground. And that's why we have administrative agencies. And this is one way which the immigration agency could be different.
Was there a question from the participants? Daniel Marcus?
You have to unmute.
Hi, Professor Rodriguez. By the way, I'm Yale Law School class of 1965.
Oh, nice. It's nice to meet you.
You mentioned the difficulty of getting any sort of comprehensive immigration reform through, which is very frustrating to those of us who favor it, because the Senate once passed a bill, but the House was Republican, then the House passed a bill, but the Senate was Republican and wouldn't pass it. So what if changing your hat to one of political strategists for a second, what would you advise President Biden to do? Should he go for broke on a comprehensive legislative proposal, or given the time constraints and the risks of the 2022 election, should he do something for the dreamers? Should he ask Congress to take the dreamers off the hook and give them permanent legal status and a path to citizenship?
Yeah, that's a really tough question. I do think that there is a strategy unfolding that resembles the second option. So one of the first things the Biden White House did was to send a bill over to Congress. And that bill bears a lot of resemblance to the one that the Senate passed in 2013. I believe that's the one you were referring to. And that was a frustrating moment, because it was a comprehensive bill that passed the Senate, and there was a majority of members of the House who would have voted for it. But there's a procedural rule in the House that John Boehner, who was the speaker at the time, invoked, which is that if a majority of the majority caucus does not support the bill, the speaker will not send it to the floor. And so since the majority of Republicans didn't support the bill, it didn't go to the floor, but a majority of the whole House would have supported it. That is an example of one of the veto gates that exists in Congress, like the filibuster, which is even more of a problem, that makes it hard to legislate. And so all of those features make it difficult on tough issues to get any legislation passed. But to more directly answer your question, I do think that sending over a comprehensive bill that highlights legalization for the dreamers and a few others. I don't know how many people here have heard of temporary protected status, but that is a congressionally authorized status that the executive can give to people in the United States who are from countries where there's been a natural disaster or civil strife that makes it hard for them to go back. And so you have people from places like Haiti and El Salvador and Guatemala who fled earthquakes and hurricanes who end up in the United States for 10, 20, 30 years because that status keeps getting renewed. And so those people have a similar status to the dreamers. They've been here for so long, the bill would recognize that they should be allowed to stay. And so I think that the combination of sending over a comprehensive bill that highlights legalization for those is part of a strategy to eventually convince Democrats to focus just on maybe the legalization for the dreamers and maybe the TPS holders who have become sympathetic, especially the dreamers. And that's one of the things that DACA accomplished, I think, was to make them sympathetic to a much larger population in the country. And it's very hard to make the case that they ought to be sent back to countries that they never knew when they're, as American as any other kid who's grown up in the United States. So ultimately, I think that is a good strategy because I think a comprehensive bill remains out of reach. Whether there's enough momentum for it, I'm not sure. But one of the things I tell my students who get disillusioned when they see bills get very close and then die, not just in immigration, but in other fields, is that if you look at the history of major transformative legislation, it can take years, if not decades, of mobilization and constant introduction of bills that define and refine what reform looks like to actually get something accomplished. And then at some point a window opens and the bill becomes a law. That's what happened in 1986. The last time there was a legalization, when President Reagan signed a bill that legalized, at the time it was only about 3 million unauthorized people in the United States, but it was significant. And that bill had been in the works for many, many years. And then there was a moment when it was in the interest of the Republican Party and the Democrats alike to sign. And it's hard to predict when those moments will arise. It's really beyond my capacity, but you have to keep fighting in case, for the moment when that window opens.
We have a question here in the chat. In the 1970s, Richard Nixon removed a law that a child born in the US could request residency for their parents. How did that come about, and could it be reborn? This is how my family was able to emigrate here. I really believe that children should have rights to a mother and father, not just property of them.
Yeah, that's really interesting. And it is the case that in order to sponsor your parent, if you're a US citizen, to sponsor your parent, you have to be 21 years old. And that is a change in the law that I imagine came about because of the concern that unauthorized immigrants who have children who are born in the United States, who are citizens by virtue of being born in the United States, could end up acquiring citizenship without actually having passed through the legal channels to get to the United States. And it's reflective of the thinking that is also challenging that birthright citizenship rule, which is that it creates incentives for illegal immigration. So even if the parents won't automatically get immigration status under this change in the law from the 70s, they have an incentive to come here for their children to become automatic citizens. I think there's not a lot of good empirical evidence that happens on anything like a widespread basis, but you can see the logic of it. And I believe that was the logic behind those changes in the law. It's interesting that rights to family unity do not play a role in the law of immigration. In other parts of the world, people have a constitutional right to family unity, or a right under the European Charter of Human Rights, for example. And so there are limits on a state's ability to deport the parents of children who are citizens or lawful residents of the country. And I think this is true across Europe. Yet in the United States, the fact that a parent who's deported will be separated from the children has no constitutional force. There are statutory provisions that allow someone to show that if their removal would impose an exceedingly significant hardship on a US citizen, then they can have their deportation deferred. But that's a very high showing. And the mere fact, there's case law to this effect, the mere fact that you would be separated from your parent, you, a US citizen child, would be separated from your parent, does not constitute grounds for exceptional hardship under this standard. And so it's I think, lamentable, as the questioner suggests, that family separation is actually built into, it's a background assumption of our deportation laws. And I think that is both a reason to think about redefining those laws, but also a reason for legalization. And where legalization would promote family unity, there's an urgency to the project.
So thank you for that interesting question, Lorena. You said there were about 10.5 million illegal residents here now. So with your increased settlement, relaxed policies, and with the proviso that you'd look to the business community for guidance on where workers would be needed, what kind of numbers are you talking about? Are we talking about 20 million? Are we talking about 50 million? How many people are would it be good for the United States to resettle in terms of net, not people going home as well?
So I think that for the present population, which is about 10.5 million, that legalizing that population would actually be beneficial both economically and fiscally. First and foremost, from a fiscal point of view, that population would be subject to taxation in a way that they are not all necessarily. Many do pay taxes. You don't have to have legal status to have a tax identification number, and many unauthorized immigrants do consistently pay taxes because that could in the future be part of demonstrating that you have met certain criteria in order to legalize. But this is not my area of expertise, but those who've done these kinds of studies suggest that governments actually save money through legalization because of the shift in taxation policy that arises. And the key feature of the current unauthorized population is the vast majority of them are settled. And legal status leads to people getting better jobs. It leads to raising standards in the sectors for all workers in which those workers without status were previously working, because it makes enforcing labor and employment laws easier or more urgent. And so with respect to the current population, legalization is not something that really presents the sorts of settlement concerns because they're already settled, and the improvement in their status will actually be net beneficial. The other feature that I think makes it possible to argue in a more general sense for legalization today is that the illegal immigration of the 1980s and 90s and early 2000s is essentially over. There is no pressure for outmigration in Mexico nearly to the same degree there was in the 70s, 80s, and 90s. And that's for a number of reasons. It includes the fact that the population in Mexico is older. It includes that it was, on average before. It includes the fact that there's been significant economic development, that there's just less demand for outmigration than there was, and it's less important to the Mexican government's own development policies, which were also focused on remittances from migrants. That's just much less important. And that the pressures that exist now on the southern border from Central America are in part because of economic deprivation, but they're also because of massive gang violence and state collapse, and in some instances because of natural disasters that lead to out-migration. But that problem is much, much smaller in scale. It is nothing like the millions of people who were entering and then settling in this period of the late 20th century that we describe in the book. And for that reason, I would be much less concerned under existing conditions about the country being in any way overwhelmed by a more generous immigration policy.
We have another question from the audience from Ryder. Are there ways we in the US can look at European laws and pull the needed information to move the rulings that the deportation of parents is morally and ethically wrong? So are there better models that we can copy?
Yeah, so I'm not that optimistic about that approach as a matter of constitutional law for a few reasons. One is that advocates have tried to make those claims in court, drawing on either international law principles or our own constitutional jurisprudence that does emphasize the importance of family ties and preservation of the family under the umbrella of the protection of liberty. But that has not gone anywhere and has not been persuasive, in part because of this, again, this baseline assumption that deportation is just a basic function of the sovereign state, that a sovereign state has both the right to decide whom to admit, but also the right to remove people who have somehow breached the terms on which they were admitted. And that there really aren't substantive constitutional limits on the decision to deport. There are due process limits on it. In other words, you have to have a hearing before you can be deported, and you can't be deported arbitrarily. But the fact of deportation is something that's baked into the power of the state. And as a result, family separation is just a consequence of that. The other reason I'm not that optimistic is that the way the courts have moved on the question of whether the Constitution limits the government's immigration power has been in a much more totalizing direction over the last few years. I actually just finished a short essay on the Roberts Court and its approach to immigration law, and it's undoing a lot of precedents that were themselves somewhat shaky, but that held for a good 20 to 25 years, that limited the government's ability, at least subject to the government's decisions about deportation, but limited their ability to deport and detain and to otherwise make arbitrary distinctions in immigration law. And so the Roberts Court is moving away from what were already pretty limited checks on government power for a variety of reasons, but they include, again, this emphasis on the political branches, being Congress and the president's authority to control the sovereign borders. And for that reason, it's hard to imagine our current judiciary as recognizing a right to family unity trumping the power to deport. But that doesn't mean that those arguments are not useful as advocacy when pressing what is now an administration very sympathetic to those claims. One of the executive orders I mentioned that President Biden announced was the creation of a task force to reunite the families that had been separated by the zero tolerance policy at the board the Trump administration issued. And that is reflective of a larger interest in managing a system that enables family unity, prioritizing families, people who come to the border seeking asylum, if they have families in the United States, are more likely to be allowed in pending their legal hearings to be with that family. And so in the political sphere, those arguments can still gain traction. The fact that this is the law in Europe might not be the most persuasive to some, but the underlying idea that unification with your family, especially when you're a child, a US citizen child, not having your parents with you, is a profound kind of claim that could have some political resonance.
So we know that Donald Trump had a rather extreme negative impact, at least from my perspective, on environmental infrastructure. But it sounds as if he basically continued what Obama was doing in terms of immigration. His rhetoric was different, but the functional performance on the ground seems to be quite similar. Is that true?
So along some metrics, that's true. There are some years where the formal deportations from the Department of Homeland Security in the Trump years were lower than in the Obama years, but there are many ways in which the Trump administration radically departed from the Obama administration. So one was its effort to try to rescind DACA, which failed. The Supreme Court ultimately ended that. And then the election of 2020 made that a decisive blow to their efforts. But the Trump administration has also took a number of steps to narrow asylum law to make it harder for people to win asylum claims, especially people coming from Central America with the kinds of claims that they were raising based on violence, and dramatically narrowed or limited the number of refugees who would be resettled. The president, under the 1980 Refugee Act, has the power to determine how many refugees are admitted from overseas every year. This is different from asylum. So there are people who show up at the border and claim asylum, but there are also people in refugee camps all over the world. And every year the president says, we're going to admit this many people from these camps who've been vetted by the United Nations High Commissioner of Refugees and meet the definition and have passed security checks. And Trump essentially shut that down. Some of you may be aware that was one of the early controversies of the Biden years, because he had promised to expand the numbers again, but seemed to have second thoughts and announced that he was going to keep the levels at the Trump levels. And there was a huge blowback from Congress and advocates. And so the administration scrambled for 2 weeks, and then it raised the numbers again. So that's actually evidence that political pressure can make a difference, because it really did in that case. And so that's just another example of how the Trump administration really was able, through the bureaucracy, to shift policy in a dramatic fashion, and in ways that are taking the Biden administration a lot of time to undo. It's not as simple as, flipping the page or turning something on that had been turned off. There are a lot of things that have to be undone through procedures that we require of our government in order to shift back. And so there's both continuity and also divergence.
Great. So I think we've come to the top of the hour, and it's been absolutely fascinating. And we really appreciate the opportunity to ask a lot of questions. And thank you so much for joining us. And we hope you can come back at some point.
Thank you. It was very much my pleasure. I'm grateful that you joined me on a Sunday afternoon, and I hope you enjoy the rest of it.
Thank you very much. And thank you everyone for coming.
Take care.
Thank you very much. Bye.
Bye. Thank you, everyone. Thank you, Jenna. Thank you, Michael.
You're welcome, Daniel.